What I want to point out is the threat to democracy, the threat to rights, the threat to the rule of law in British Columbia by the passage of undemocratic passage of bills that don't have any legitimate public purpose and that restrict or extinguish rights, even rights that under international law cannot be restricted. Now, in response, you have to ask yourself, what have we heard from government in response to very informed and widespread opposition? What the government has said in response they've made chilling and unsubstantiated statements citing the need to modernize and streamline. Now, that's frightening. If anybody tells you that a statute has to be modernized and streamlined, you've got to ask them what exactly they mean by that. They've also cited, with respect to both the HPOA and Bill 29, that there is a need to protect people from the harm that could be caused by health professionals and occupations and by the legal profession. Now, how Orwellian is that, given that doctors and lawyers are people that you go to when you have medical or legal, when you're faced with medical or legal harm. So in addition to the alarming characteristic of them both being tabled, one being passed and the other one about to be rammed through in the spring session, I fear, without any proper consultation or democratic process. These are other things that the two proposed bills share in common. They both lack a legitimate statutory purpose. They both abolish, basically, democratic governance of health professionals and occupations and democratic governance of lawyers. Then they go ahead, once that's cleared the way, they go ahead and they impose undemocratic lawmaking by a virtual waterfall of political appointees. Now, the political appointees, because they're appointees, they're not under both the proposed laws. The appointees aren't required to be accountable. Of course, they're unelected, and we can reasonably assume that they will likely be incompetent. Yes, and that's only reasonable to assume.